in case this doesn't record.
Give you a thumbs up, Dave.
Okay, we're good. Welcome to the Norfolk Conservation Commission. Today is April 17th. Please be aware that this meeting is video and audio recorded. We have one action item, and that is old business. A discussion of investigation of possible Wetland Act and bylaw violations at 144 Seekonk Street and enforcement options. We discussed this last week, but our agenda didn't identify the address of the applicant, so we were in violation of open meeting laws, so that's why we're meeting today. At that time, we heard from our attorney, Mr. Hill, and we discussed all the relevant information on 144 Seekonk Street. And at that time, the board was full, and we did vote to send a letter to Mr. O'Hart asking for permission to get on the property. Since we were in violation, we have tonight's meeting. We have a quorum of 4 people out of 7, so we can proceed on this, and we're in no violation of any open meeting laws. This has been going on for a little while, the 144 Seekonk Street. What I'll say the 2019 Conservation Commission, we're looking at this without prejudice, and what we are acting on is information we got from when an engineer went out last year for the ZBA and made a comment regarding wetlands and possible disturbance, and we've had an abutter do the same. So what we would like to do as a Norfolk Commission, Conservation Commission, is send out an agent, our agent, along with an engineer to survey the wetland area and see if there are any violations, and also duly note them, because as this development continues, everybody needs to know where wetlands are, and that's our purpose in life, and dictated by the state. So with that, we have the letter from last week. Dan, do you want to say anything before we discuss it?
Sure, I can just provide some context. And since we are reconvening this meeting, it would be prudent to go over the issues and the facts again, even though we did it last week, just so the record's complete. And just for the record, there was an allegation that the agenda item was not clear enough under the open meeting law. We're not suggesting that we're making a determination tonight that there was a violation. We're just simply doing this hearing over. It's not a hearing, actually, it's a meeting, but we're just doing the meeting over to the extent that there is a violation. So in light of that, I think it would be smart for me to give a brief overview of the history, why we're suggesting that there be an investigation, and what that process will look like. So first, the brief history. This property at 144 Seekonk is the subject of a proposed multifamily housing development that's relatively intense in terms of the use of the site. There's a lot of units, and this property has a wetland system that runs through the middle of the property. The wetland system consists of a bordering vegetated wetland, and there's a few, or at least one isolated vegetated wetland. About a year ago, I guess more than a year ago, the fall of 2017, the property owner was doing some work out on the property, clear cutting, building a road, and the building inspector issued an enforcement order under the zoning bylaw, and alleging that the owner had not complied with the zoning bylaw requirement that you can't just clear cut property without a permit. So that stop work order was appealed by the owner to the zoning board, which is the process under the Zoning Act. And the zoning board, acting as a quasi-judicial entity reviewing the reviewing the building inspector's order, essentially heard both sides and made a determination that, in fact, the zoning bylaw violation occurred. In making that finding, the zoning board collected some evidence, and what it did is it hired a surveyor to go out onto the site and to inspect and to gather evidence to see if there's any merit to the allegation of a violation, and also to assess the defense that was raised by the property owner. So that report concluded that there was in fact a lot of clearing on the site. It itemized the clearing. That report provided pictures and diagrams, and the report concluded that there was a lot of clearing that violated the bylaw. That report also identified potential wetland alterations that were done in the past. It wasn't clear when they were done, and it was not definitive. It was just the author of the report, Patrick Garner, just flagged these issues and suggested that this might deserve closer attention. But because the zoning board has limited authority, that certainly doesn't have authority over wetland alterations, the zoning board didn't take any action on that issue. So the report mentions potential wetland alterations, but it didn't. No conclusions were drawn during that process. So that enforcement order was affirmed by the zoning board, and the property owner did not appeal that to court, so that became final. Subsequent to that process, we reviewed some additional documents in the file for this property, and we found a plan showing a proposed subdivision. It was called Oak Knoll Estates, and Amy's going to pull up a plan on the screen. About 10 years ago, 15 years ago, this site was surveyed for wetlands by somebody completely different. This wasn't the owner, it was a different owner. And there was a wetland survey plan prepared. My understanding is that this wetland plan was never submitted to the Conservation Commission for approval under an ORAD process, but it was delineated by somebody with some credentials. So this plan shows wetlands that are significantly larger than the wetlands that the applicant surveyed and which was approved by this commission under an ORAD. Now, the ORAD was issued prior to all this, but an ORAD is not binding on past historical alterations. So what an ORAD does is it just certifies the current extent of a specific wetland resource area. In this case, the property owner applied for an ORAD to have the commission certify the location of a bordering vegetated wetland. That's it. So that was ultimately approved by the DEP as a superseding order of resource area delineation. That order of delineation has no effect on whether there were past alterations that were not approved. So that was an issue that I know counsel for the owner has raised. He believes that the law would say that because an ORAD was issued, you can't look back at past violations, and that's simply not correct. And he's free to make that argument, of course. If he wants to appeal this to DEP, he can do so. So where we are here tonight is we've got a project that's soon to be before the zoning board. That project is a very intense development of the site, which includes a road in the location of where it appeared wetlands occurred or wetlands existed in the past. So the impetus for investigating whether those wetlands are altered illegally is this project that's going to be before the zoning board. And if those wetlands were altered, then there would be an appropriate enforcement order that would require restoration of the wetlands. That would change the way the project is reviewed by the zoning board. Now, because it's a 40B project, the zoning board actually steps into your shoes for purposes of the local bylaw, so it would administer the local bylaw. It would administer an order of conditions that you would ordinarily issue under the local bylaw. But this commission would still retain jurisdiction for purposes of the state act. So what we've recommended this commission do is look into whether, in fact, there were alterations of the wetlands on the property since that plan that is on the screen. What's the date of that plan? Just so we have it clear. 2007.
March 8th, 2007.
Yeah, so over 10 years ago. So the question would be, were these wetlands altered? And the area in question, if I can just show on the screen, is this bubble here. So the current line that was approved by the commission and the ORAD, the wetlands ended somewhere in this vicinity. So all of this is shown here on this plan, but is not shown on the current plan. And Mr. Garner also believes that there was a stream that moved up in this direction, actually well into this area here. He also believes that there is a isolated wetland pocket over here in that location. So the next step for this process would be to just look at the site, have an agent go on the property, do some very minimally invasive soil sampling, and whatever else these experts do to verify or to check to see if wetlands were filled. So the next step would be to have our agent go out on the property and do that work. To get out on the property, we either need permission from the applicant, landowner, or we would have to get an order from the district court judge, which is a civil administrative warrant. It's a fairly common process in Massachusetts, and there's regulations that specifically allow for that. So I think it's important to keep in mind that there's no predetermined outcome here. No one is suggesting that these wetlands have in fact been altered. The inquiry is, have they been altered? And if so, what is the appropriate remedy? And the reason this is happening today rather than a year from now is because this is all relevant to the development or the proposed use of the property under the comprehensive permit. So I think what we did last time and what I'd recommend again is the commission to vote to authorize the initiation of the investigation, and that would include sending a certified letter to the applicant, which we did on April 11th. We'll do it again. We'll set a new deadline for the applicant to respond to either give us permission or not. And the authorization for the commission would include the site visit by your selected agent, who I believe is Mr. Garner. And if we don't get permission, that we would then proceed to the district court to obtain the warrant that's needed to get on the property. And then after that investigation is done, you would get a report from Mr. Garner, and from our firm, we'd sit down again, we'd have a meeting to discuss what the next steps would be.
Thank you, Dan. Any questions for Dan? So, any discussions on all the letters and emails that have been passed by over the last few days? Okay, so you're all brought up to date on what the history has been, and where we sit today is without prejudice going on the site with Janet would go along with our hired person, which is Pat Gardner. He was the low bidder. And then the owner, Mr. O'Hart, is can have somebody with them. It'd be preferable if they had an escort, so that when things are done on the property, they're witnesses of exactly what is done. So when the report comes out, it's valid, and versus the one from the ZBA where they didn't have anybody present, and so then they're challenging different actions on that. So what we'd like to do is entertain a motion to resend the letter to Mr. O'Hart on regarding 144 Seekonk Street, and have him reply by April 22nd, which is Monday. Is there any comments, questions from the audience? Go ahead, you state your name, get the microphone, please. State your name and address.
My name's Diane McElwee. We've lived at 152 Seekonk Street since 1983. I was wondering if the board would be interested in a list of animal species, plant species, anything that we've witnessed over the past 30 years that we've seen on this property before even Mr. Wahat owned it. My kids personally witnessed many things. That was their playground for many, many years. And it truly was a watershed. There are deer trails, there are fisher cats, there are coyotes, there are turtles, salamanders, owls, all kinds of things. There are also plant species, lady slippers, native arborvitae. I think there are a lot of things that need to be investigated because it truly is a conservation.
We would be interested in the plants. All the other ones are not our jurisdiction.
Okay.
But the wildlife, people from the state would then get involved in it, but that I think is later on in the process
Okay.
as this application goes through.
The state has a list, state wildlife has a list, and how the process sort of works is that there's first-hand eyewitnesses that are sent, they send letters to the state that says this specific species in this area, and then they'll validate it. That's how they approve, if they looked at this site and they have specific animals, salamanders, turtles, that they're looking at, they propose this. There's have been no sightings on it. The State Wildlife Commission then states that this is clear of what they assume. But if you've seen one of the list of items that are on the endangered list, then the only way for the state to know is for someone to report it. The normal type of animals that roam in the forest, unfortunately, aren't going to stop a project like this. If that, I kind of think that's what you're, the state is interested in helping endangered species. And those are the ones that, if there was a turtle nesting area, that they would make sure that there were proper boundaries around it and free space around the water area, and, you know, the 100 to 200 feet away for nesting and all of that. So that's how the wildlife version works. As far as the plants go, there's also endangered plant lists, and the same thing applies.
And so when this walkthrough happens, that looks like it may happen, will they be looking for these
No.
things? No.
They'll
So that
just
comes
look at
later.
water issues.
I see.
Yeah, there's actually there'll be a separate permitting process, which is when your testimony and evidence would be relevant.
Okay.
This project, if it gets through various stages, would eventually have to come to the commission
Okay.
for what's called an order of conditions. And the kinds of things you're referring to would be relevant at that stage. But what we're talking about here today is simply whether or not certain areas of wetlands were filled. So it doesn't really go to the birds and the
Okay. Even though they
turtles.
ended up in my swimming pool, driven out and end up in
But
my
that doesn't
swimming
mean you couldn't submit things. I mean, if you wanted
I'll
to.
trap them and bring them.
No, thank you.
Thank you.
You're welcome.
Good evening. Mike Kaliza, 18 Creek Drive. I just wanted to make a couple of quick comments. I've been a member of the ZBA for over 20 years now, chairman for 6 or 7, currently the vice chair. And we're happy that the Concom is taking a look at this. We've referred it to you, as Mr. Hill so aptly explained, because it will affect the type of development that he can do on that property. If it is proved that wetlands were filled in, it will reduce the scope and density of the project. So as you might guess, density is a major concern of ours. It's a very large project right now, I believe at 96 units. If your board does determine that wetlands were altered, it will significantly change the scope that he will be able to develop in that area. So obviously, our concern is that and we're happy that you're moving forward with this because it will help us come up with a better project for the town of Norfolk.
Thank you. Again, this survey that will happen is to identify all the wetlands and determine if there were any violations of those wetlands, and using past maps and what the information in hand. Any other comments from the board?
We just got to make absolutely sure that the commission, regardless of the use of the property after our vote, we can only vote on the fact and the delineations and what the research shows. Not any opinion on whether it's going to be a development, whether it was going to be a farm, or what the use was after the fact that it comes through for delineation. So we just want to make sure that, we have to be as fair to the people that are coming out that don't like it as we have to be fair to Mr. Hart, who has a right to develop it. So, and it becomes a giant issue if it appears that we are swaying one way or the other. And so I hope you understand that. So we, as the chairman has stated, that we are coming in, regardless of what's been shown before, we're going in with an open mind to look at what has done, which will in the long run be most benefit to all of us.
Thank you. Okay. I will entertain a motion to resend the letter that was read last week and have it due back by April 22nd, or we'll take whatever action we need to take to get on the property.
And I think actually, Mr. Chairman, the motion last week specifically authorized our firm to
Do it.
quarterback, for the lack of a better word, the investigation with Mr. Garner, including, if necessary, to obtain the administrative warrant for the inspection.
Okay. That, Hill Law Firm is representing us on this issue, and will send a letter and keep us informed of any correspondence, and we'll take action with the law firm as required. Okay?
So someone needs to just say, "So moved," someone needs to second it, and then there needs to be a vote.
So I make a motion that we resend the letter to Mr. Hart from the Hill Law Firm, have him respond by April 22nd. Hill Law Firm will be responsible for taking the action further if no response, or appropriate action if there is a response, and then to move forward with any legal action that we need to get through district court to get on the property, to get the person that bid on researching the damage to the wetland areas, according to our meeting last week.
I second.
Okay. All in favor?
Aye.
Aye.
Opposed? The motion passes. Please, Mr. Attorney Hill, send the letter out tomorrow, and we await their response.
Okay, will do.
With no other business, I will entertain a motion to close.
Do you have anything, Rich?
Actually, before you,
Yes.
I'm sorry, there was a correspondence from Mr. Agostino. Just want to make sure that gets entered into the record.
Yes,
If you haven't seen it,
the one from today.
yeah, it came in late this afternoon,
Okay,
so it's in the record. Okay,
okay,
thank you.
thank you.
Right here too, if anybody wants to.
Yeah. So I'll entertain a motion to close.
I move to close.
Second?
Second.
All in favor?
Aye.
Aye.
Opposed? It passes. The meeting is now closed.